Yes.
Okay. Thank you, sir. First of all, I welcome Honorable Sri Khaja sir, District Judge First and Additional Session Judge Dhule, in this third online session, online guiding session for the preliminary examination of District Judge 2024. Dear participants, we are quite having a good news that lot of judges are ready to guide us, and we have started our session from the Lordship, and today we are having a renowned personality who is going to guide you on the criminal law, the criminal procedure code and BNSS. So before going to start the session, I want to introduce Honorable Sir. Honorable Sir is basically from Bid district, Maharashtra, who is from well-educated and renowned family, who has overall educated, as well as the father of Honorable Sir has already worked as a law teacher. So teaching and guiding is itself in the nature of Honorable Sir. Sir has completed his education from Bid district as BA or graduation in English medium. Along with that, history and economics are the optional subjects. Now after that, respected sir has completed their LLB in 1992 along with first division. From 10th to LLB, all the 12th, 10 graduation and LLB is thoroughly passed in the first division. Sir has completed his LLM in 1994 and even completed the PhD in criminal law in 2008. So during his education, Honorable Sir has practiced, after completing LLB, has practiced up to 6 years at Bid and subsequently selected as an civil judge junior division as well as JMFC in 1999. And from 99 means from 25 years, respected sir is working as a judicial officer in different districts of Maharashtra, and right now sir is working as an district judge first and additional session judge Dhule. So respected sir is having lot of experience regarding judicial work as well as having the PhD in criminal law. So we are quite happy as well as we are lucky that today we are having a renowned personality who will guide us on the upcoming examination of district judge preliminary. So on behalf of our group, I personally welcome to Honorable Khaja sir and request to sir that please guide us. Over to you, sir.
And very good evening, respected participants and Dr. Ajay Mehkarkar sir. I am short of words to express the gratitude for introducing me and using quite big words for me. Friends, today in the free online guiding sessions, I am dealing with the topic of criminal laws, more particularly the Code of Criminal Procedure and the newly introduced Bharatiya Nagrik Suraksha Sanhita by replacing the old Code of Criminal Procedure. You know well that India was a part of British colonial empire. Till 1947, we were part of the British colonial empire, and in 1947, we got the independence. The establishment of East India Company in the year 1600 and its gradual approach towards taking over the power, and we have to fight the battle of independence, and then you know the uprising of 1857, then Queen's Proclamation. After Queen's Proclamation in the year 1861, the task was taken that the India was completely a part of British colonial empire, and initially the task was the laws that were to be implemented in the colonial empire of India. Of course, the laws passed by the British parliaments were introduced in India as we are part of British colonial empire and British supremacy. The great statesman Lord Macaulay, Lord Babington Macaulay has taken up the task of drafting the major penal law for this country, and due to his strenuous endeavors, the Indian Penal Code 1860 was drafted by the first Law Commission. It was a major penal law in force in our country, dealing with all the offenses. The punishments for those offenses were prescribed in the Indian Penal Code. And till 2023, it has been replaced by the Bharatiya Nyaya Sanhita 2023. The Indian Penal Code was a major penal law in force in our country. You were all were students of law and you know well that there are two types of laws, substantive laws and procedural laws. Likewise, the Indian Penal Code, being substantive law, defines the various offenses and lays down the punishment for those offenses. So after drafting Indian Penal Code and implementing it in the British colonial empire from 1861, the need was felt that it is a substantive law, deals with the offenses and the punishment. There must be some procedure prescribed for dealing with those offenses, punishing the guilty, punishing the wrongdoers, punishing the persons who are guilty of the offenses which are defined to be the offenses under the Indian Penal Code. And a need for the procedural law, a general procedural law was felt, and that need led to the codification of the Code of Criminal Procedure in the year 1863. So we have a major penal law in force. Then we have also the procedural law in the form of the Code of Criminal Procedure in the year 1863. Then the need was felt, the mode of evidence to prove certain offenses. And unlike Babington Macaulay, it was Sir James Stephen Fitzgerald, who was eminent lawyer and then judge of his time. He has taken up the task of drafting Evidence Act. And the Indian Evidence Act was drafted in the year 1872. Let me be very honest to share it with you that the Indian Evidence Act was one of the most perfectly drafted piece of legislation, free from all anomalies, free from all flaws. Though it is included as one of the criminal major acts, but in fact, Indian Evidence Act is equally applicable to both civil as well as the criminal proceedings. The mode of proof required for the civil proceedings as well as the mode of proof required for establishing the guilt of the accused is laid down in the Indian Evidence Act 1872, and we must acknowledge the contribution of these statesmen, Babington Macaulay and Sir James Stephen Fitzgerald, for giving us the penal law as well as the law of evidence. The procedural law has changed from time to time, taking into consideration the need and to make it more befitting to deal with the procedural. The procedural laws are generally to simplify the procedure. Procedure for dealing with the trials, the inquiries, and the investigation shall not be complex. And considering that aspiration, the Code of Criminal Procedure was amended from time to time. The major amendments by replacing most of the provisions of the Code of Criminal Procedure was done in the year 1973 and subsequently in the year 1976. And after Nirbhaya also, there are certain amendments introduced both to the penal law as well as to the Code of Criminal Procedure. After 1976 and then 2000, From 1st July, we have a completely replaced code of criminal procedure in the form of Bharatiya Nagrik Suraksha Sanhita. And we have done away with the old code of criminal procedure. Now, as regards to the applicability of the procedural law, see that these three new criminal laws, that is the Bharatiya Nyaya Sanhita, which has replaced the Indian Penal Code 1860, then the Bharatiya Nagrik Suraksha Sanhita 2023, which has replaced the old Code of Criminal Procedure, and then the Bharatiya Sakshi Sanhita or the Bharatiya Sakshi Adhiniyam, which has replaced the Indian Evidence Act 1872. These laws, the task of these new criminal laws was given to the National Law University, and Dr. Rao of the National Law University has taken up the task of drafting these new criminal laws under the head that a committee constituted for criminal reforms. Our criminal justice system is poorly rated for the reason of the delays in the investigation, inquiries, and resultantly in the trials. And the technicalities, the non-proper use of the investigative methods, non-optimum use of the forensic sciences, non-optimum use of the electronic gadgets, the electronic mediums in the investigation, in the inquiry, and the trial was taken care of, and need was felt that there shall be newly reformed criminal laws, both on the aspect of substantive law as well as on the aspect of the procedural law. The Code of Criminal Procedure was general procedural law governing all criminal proceedings, which has been replaced by this BNSF. Why I'm saying so, that there are so many criminal minor acts. Of course, we have these three criminal major acts, which I have just said to you. So there were a number of criminal minor acts, may be Narcotic Drugs and Psychotropic Substances Act, may be Food Adulteration Act, may be Drugs and Cosmetics Act, may be so many minor laws to deal with different eventualities, different crimes in different fields. Even for sands and mines, we have Mines and Mineral Acts, so many laws, even for beggar there is a law. So there are so many minor laws, but for trial, for the investigation and for the inquiry purposes, while enforcing these minor enactments, the procedure is only the Code of Criminal Procedure. Now it is BNSS. So procedure and procedure law, the object is to simplify the procedure. Now, you know well that after independence, Constitution of India is the supreme law of the land. Rather, Constitution is the mother of all laws in India. And no law, no enactment which is in force shall be contrary to the Constitution of India. So supreme law of the land is the Constitution. But at the same time, there are other laws to deal with different types of eventualities. But one thing we have to bear in the mind at the same time, certain rights which have been guaranteed, may it be in the form of constitutional rights, may it be in the form of the fundamental rights that have been enshrined in our constitution from Article 14 to 31, and for which the remedies provided under Article 32. These are called as the constitutional safeguards. These are called as the fundamental rights. These are the rights guaranteed under the Constitution. All rights that have been protected by the Constitution are not the fundamental rights. There are certain rights which are no more fundamental rights, but are guaranteed under the head of the Constitution. Like initially we have right to property as a part of the fundamental right, but now we don't have right to property as a fundamental right, and it is a constitutional right. Right to vote is not a fundamental right, but it is protected by the Representation of People's Act. And it is not a constitutional right nor a fundamental right, but It is a right protected under a particular enactment, that is the Representation of People's Act. So procedural safeguards, procedural rights have been granted, are guaranteed under the Code of Criminal Procedure. In verbatim, they are taken in the newly replaced Bharatiya Nyaya Suraksha Sanhita in some modified form. Certain new definitions have been introduced which were not the part of the old Code of Criminal Procedure. So certain changes have been brought. You know well that the earlier Code of Criminal Procedure also deals with the power of police to arrest, then the prosecution, and then the bail. But now a major change that has been introduced by this newly replaced BNSS is that it mandates forensic investigation for the offenses which are punishable with 7 years or imprisonment or more. And forensic experts will visit crime scenes, and when forensic evidence is collected, it becomes a part of the record of the investigation or part of the record of the inquiry or part of that particular process. You know well that in all the inquiries and in all the proceedings which may be held now, electronic mode, the electronic mode of protection of electronic communication devices likely to contain digital evidence will be allowed for investigation, inquiry, or trial. So use of forensic sciences and use of this electronic mode is made mandatory now in all the offenses for which punishment prescribed is 7 years or more. So in the offenses like rape, murder, child sexual abuses, where punishment is certainly above 7 years of age, the mode of investigation must be scientific investigation, and the use of forensic sciences shall be more, and it has been made mandatory. Because you know that investigation is nothing but collection of evidence. Whatever is best possible evidence you can collect, the best you can be able to establish the guilt of the accused. Best possible evidence means evidence which is of scientific nature, which is more accurate, and where there is no scope for laches or flaws. Forensic basically means in relations to the court of law. So forensic sciences means those sciences which are in relations to the court of law. So this is a major thing that has been provided toward the investigation, inquiry, and trial. You may say that in investigation it's okay, but during the course of trial, so the mode of proof of electronic evidence or mode of proof of forensic evidence that has been prescribed. So now we are recording the evidence through video conferencing. It is one of the electronic mode that we are using for recording the evidence. Now, establishing or proving forensic evidence, the reports of the DNA, that is deoxyribonucleic acid test reports, that proving electronic evidence in the form of certain audio visuals, then digital cameras, and the portraits and the picture that has been drawn from the electronic communication skills and videos, digital cameras. All these things are to be produced before the court. They are to be proved in accordance with the procedure prescribed for proving the electronic evidence. So the mode of recording and the mode of proving electronic evidence is also one of the means that we are following in the trials. So use of forensic medicine, then use of electronic gadgets has been made mandatory, and it is one of the mode which will facilitate the court in early disposal of the cases, and the time consuming process for the trials can be curtailed by the optimum use of the electronic modes and devices, and that has been taken care of while introducing this new law. For the first time, the act or the code. Now, this also I want to make clear to you. So what is act and what is code? Act is always enactment of the legislature. So when you call any particular enactment as an act, so it is clear that it is a creation of an legislature. It is a creation of the legislative machinery which has to enact the laws. Good. The code is, in a sense, that it is a compilation of the existing rules. So like act, many a times code is not act of the legislature or it is enactment by the legislature, but of course it has approval of the legislature, but it is compilation of the existing rules. That's why it is called a code. So we had code of criminal procedure. So it is a compilation of the existing rules which have been accepted as a part of the procedure after approval, of course, by the legislature. So BNS is rearranged in the form of certain existing procedural niceties and procedural part. But one thing that is needs to be shared with you is that see, this is aims and provide faster and more efficient justice system by doing away with the complex procedure. The statement of object of this BNS is for achieving faster and more efficient justice delivery system. The delays, inadequate use of technology, forensic sciences has been taken care of. But in the old Code of Criminal Procedure, we have only 484 sections. In BNS, we have 531 sections as compared to 484 sections in the old code. Likewise, in the old Code of Criminal Procedure, we have 37 chapters. In the BNSS, we have 39 chapters. It is not feasible to trace each and every section, but we can highlight on certain aspects which needs to be taken into consideration and which are important for your purposes. See, for the first time, this BNS has tried to define what is bail, which has not been defined under the old code. And it is section 2B of this BNSS which has replaced the Code of Criminal Procedure. Bail means release of a person accused or suspected of commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or a bail bond. And bond means an undertaking for release without surety. So bond has been defined as an undertaking for release of a person. In the old code, bail has never been defined. And we have borrowed the concept of bail from judicial pronouncements. And it is only, to the best of our knowledge, means bail means release. But here, for the first time, bail has been defined under section 2B of BNSS as release from a certain custody or release from the conditions imposed. Bail is a rule and jail is an exception. This was the concept highlighted by the superior courts of the country. More particularly, in one of the judicial pronouncements, Justice Krishna here has said that bail is a rule and jail is exception. So curtailment of liberty shall not be casual. Liberty is as supreme as oxygen. So casual interference with the liberty of the person shall not be encouraged. And that's why in the old code there was one provision that if a person has undergone half of the punishment which is prescribed for a particular offense, he must be enlarged on his personal bond. But that has been done away by BNSS. And now it is said that when a person is guilty of number of offenses, all similar offenses, in that contingency, even if he has undergone half of the punishment in the prison or incarceration, that cannot alone be a criteria to enlarge him on bail. To be more specific, you see that rash and negligent driving is an offense under the old Indian Penal Code or in the Bharatiya Nyaya Sanhita now. It is also an offense under the Motor Vehicle Act. So if a person is an accused of the offense for rash and negligent driving, which is made punishable under two different enactments, that is the Bharatiya Nyaya Sanhita now and as well as under Motor Vehicle Act. Then even after going half of the sentence period prescribed for a particular offense in incarceration, that will not be ground under the news BNSS for enlarging him on bail. Similar example can be given in case of sand mafias. You know that lifting sand unauthorizedly, unlawfully is made punishable under the that Mines and Minerals Regulation of Rules Act, as well as it is a punishment. It is an offense under Section 379 of the old Indian Penal Code. In such contingencies, that benefit cannot be given to such an offender. See, the use of electronic evidence and use of forensic sciences. So for the first time, this term audio video electronic means has been defined under section 2A, and it lays down that audio video electronic means shall include use of any communication device for the purpose of video conferencing, recording of processes of the identification, search and seizure or evidence transmission of electronic communication, and for such other purposes and by such other means as the state government may by rules provide. The BNSS is a central legislation. It applies to whole of India except Nagaland and other tribal areas. After abolition of Section 370, the Code of Criminal Procedure was not applicable to the state of Jammu and Kashmir, but after abolition of Section 370, it was made applicable to the state of Jammu and Kashmir also. But BNSS is post abolition of Section 370, post abolition of Article 370 of the Constitutional Body. Then it is made applicable throughout the territory of India except Nagaland and other tribal parts where the Code of Criminal Procedure is not applicable. However, a care has been taken that in case of any contingency as regards to the use of electronic modes and the video audio recording and all these things, rules can be framed and those powers to frame the rule are vested with the appropriate government. As the case may be, this may be central legislation, even the rules can be framed by the union as well as the rules can be framed by the state government, and that will be the state rules. Because in investigation also, the use of audio video recording has been made mandatory. The searches of the places of offenses, the searches for the search of the property, then the recording of panchnamas at the scene of the offenses, for all audio video recording has been made mandatory. So some rules have to be prescribed for the said purposes, and that is laid down that for that purposes rules will be framed. So audio video recording, audio video electronic means are not only the part of inquiry or investigation, that has also been made a part of the trial purposes. And more particularly, whenever offense is punishable for 7 years or more, it is mandatory. It is mandatory that while searching a place, you must have video recording with you. while drawing the Panchanama, maybe inquest Panchanama, that is in respect of the dead body of the deceased, maybe in respect of seizure of certain property at the place of incidents or at the scene of incidents, maybe while searching the property, even in case of test identification parade, when person is mentally challenged or suffering from any mental illness, for identification parade or test identification parade also, this audio video recording has been made mandatory now. Now, as regards to bail, I have said that it is released on certain conditions and on the undertaking given by the accused, and this has been defined. One major aspect is the definition of victim of crime has been changed or modified under the new BNSS. See that under the old code also term victim has been defined, but with certain new notions, the term victim has been defined. You know that all procedural safeguards, all constitutional safeguards are moving around the rights of the accused. Even in case of an accused in Hossein Ara Khatun's case, the Honorable Supreme Court has created a mere postcard to be infringement of the right, and it was taken to be a writ petition, and so much of cognizance has been taken by the Supreme Court. So our entire criminal system and criticism is that it is protecting the rights of the accused and it moves around the rights of the accused. And it is very much conscious about the rights which are guaranteed to the accused under the Constitution as well as under the procedural law. But at the same time, victims of the crime shall not be neglected, and the concept of victimology has assumed significance. That in the entire judicial process or entire system of administration of justice, the victims of the crime shall not be forgotten. And that's why, while considering the concept of victimology, we have to be aware of the definition of victim and new BNSS with certain new notions has defined victim under section 2Y as victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person and includes the guardian or legal heir of such victims. So any person who has suffered any loss is a victim of crime. Injured, who has been beaten up, who has been assaulted, who has become victim of voluntary assault, or who has suffered any loss. Loss includes both mental, physical, and monetary as well. And then caused by reason of act or omission of the accused person. So this loss must be attributed to the accused because of the accused. He must be the author of those laws, injury, and he must be the person responsible for such monetary loss to the victim. Then includes guardian or legal head of such victim. You know that in accident claims, the person loses life and parents approaches to the court of law, the dependents approaches to the court of law and claims compensation. They are the victims of that accidental death. They are victim of that accident. They are victim of that mishap in which they have lost their son, they have lost their husband, they have lost their father, on whose income they were totally dependent. So any person who was totally dependent on the income of the deceased, any person who has suffered due to the loss of life of a person, his parents, his guardian, his legal heirs are included in the definition of the victim. Suppose in case of a murder, the next kin of the deceased, the next kin of the victim, the next kin of the person who met with death due to culpable homicide, may be amounting to murder, may not be amounting to murder, are included in the definition of a victim. And this care for the first time has been taken care of. Now, another very important change that has been made by this act is regarding registration of the FIR. Initially, the first information report was governed by section 154 of the old code. You know that it was a public grievance that the police is reluctant to register the crime. Police is reluctant to register the FIR even if when it discloses a prima facie offense and offense of a cognizable nature. Then also the victims of the crime, the informant has to rush from dusk to dawn for lodging his FIR, for registering his FIR, but police is reluctant. Now registration of FIR has been made mandatory, has been made compulsory. You cannot avoid. Whenever the report discloses commission of any cognizable offense, you cannot avoid it. And Honorable Supreme Court of India, if you are interested in taking down the citation, it is a celebrated case of Lalita Kumari versus State of UP. The citation is 2014, Supreme Court cases 1. In Lalita Kumari versus State of UP, the Honorable Supreme Court of India has taken care of this public cry or public grievance and reluctance of police to register the FIR even when it discloses a commission of cognizable offense. Now a police is duty bound to register the FIR, irrespective of the fact where offense is committed. Previously, FIR needs to be lodged within whose jurisdiction the offense is committed. The police station officer of the particular police station in whose jurisdiction the offense was committed was duty bound to register the FIR, are bound to register the FIR, but now irrespective of jurisdiction. Jurisdiction means extent of authority. The definition of jurisdiction is extent of authority. So in whose jurisdiction a particular offense is committed is duty bound. Now, even if an offense is committed in Punjab, FIR can be lodged at Dhule. Irrespective of jurisdiction, it has been made clear under 173(1) of the BNSS, irrespective of jurisdiction. Now, even if an offense is committed in Kerala, FIR can be lodged in Maharashtra. So
Prashant,
that FIR is to be registered with unknown number, and that has to be registered with unknown number, and it is called as zero FIR. And initial investigation has to begin. Initial investigation has to be started. Initial inquiry has to be started. And furthermore, for further investigation, the report which is registered with unknown number as zero FIR has to be forwarded for further investigation purposes to the concerned police station. But merely for want of jurisdiction, you cannot refer to register the FIR. However, mind it well that the procedure as regards to jurisdiction of the police station is the same as per in the old code of criminal procedure. Another very important aspect is that as regards to the remand and the police custody. You know well that there are two types of custody, that is police custody remand and judicial custody remand, which is also called as magistrate custody remand. There shall be no confusion in the mind. When the magistrate grants custody, it is a magistrate custody. When a sessions judge grants custody or any other judicial officer, then the magistrate grants the custody, it will be a judicial custody. So judicial custody remand under old 167 and now under section 184 of the BNS, see the first 15 days remand is for the purposes of investigation and that other custodial interrogation. So first custody must be a police custody under the old code. And a celebrated judgment, you know that the Central Bureau of Investigation versus Anupam J. Kulkarni, 1992 AR 1768. In Anupam Kulkarni's judgment, he said that the first custody must be a police custody, and after 15 days, that is what the ratio says, is only a magistrate custody or a judicial custody. But now it has done away the decision in Central Bureau of Investigation versus Anupam Kulkarni and subsequent judgment in case of Balaji versus State. Now the 15 days period must not be only the initial period, and that 15 days period for police custody purposes shall be taken as a whole in first 60 or 40 days out of 60 or 90 days as the case may be. You know well that up to 10 years, where punishment is up to 10 years, the investigation must be completed within 60.
बरं ते मधलं बरं ते 9 नंबरला हे तू इथूनच बसून देतो तिकडे नाही येत.
However, in case when the investigation relating to the offenses where punishment is more than 10 years, maybe up to life imprisonment, the charge sheet needs to be filed within a period of 90 days. In that contingency, as a case maybe 60 days or 40 days, you have to carry out the investigation 15 days period, maybe middle period of 15 days or at the end period of 15 days. And it is not only the first 15 days period as was expected under the old code. So 15 days period will be for the purpose of investigation, and then it may be initial period, it may be middle period, or it may be the last one period. Likewise, once charge sheet has been filed, no court shall make haste to frame the charge under the new BNSS and 60 days period. You see that for all purposes, they have prescribed the time frame. For framing of charge, first 60 days you have to wait for discharge. Without even making application, court has to wait, and court shall not make haste in framing charge even after committal of the matters, because charge sheet is filed in the court of magistrate, and since the offences are tried by the court of sessions, the matter is committed to the sessions court. So after committal of the case, the sessions court shall wait for 60 days because it is the right of the accused to ask for discharge. When material is sufficient on record to proceed with the trial of the case, court shall proceed with the framing of charge. Charge is nothing but a precise formulation of specific accusations made against a person of the offense of which he has to answer. So it is with the object that the accused should know what are the accusations against me. And it is only when the accusations gone unrebutted would warrant into conviction of the accused, charge needs to be framed. But when framing of charge and proceeding with the trial is itself a futile exercise, then court may discharge, because even if the material is accepted, no offense can be said to be made out so as to proceed with the trial, and trial will be a futile exercise. In that contingency, accused needs to be discharged. So court has to wait for a period of 60 days under the new BNSS for framing of the charge, and that custody period is 15 days as a whole in 40 days or in 60 days as the case may be. This has been prescribed for all purposes. Timelines for various procedural formalities has been prescribed. You know that initially for proceeding against public servants, sanction for prosecution was required under old code 197 of old code of criminal procedure. You may see the relevant section which has been corresponding to 197, and it is said that time consumed for months together for obtaining the said sanction. Whenever any offense is committed by a public servant while discharging his official duty, then for prosecuting him for the said particular act or any offense committed by him or allegedly committed by him, sanction was required. And sanction is not accorded within a time frame. Now it is said that If suppose sanction is not granted within a period of 120 days, it is considered to be a deemed sanction for prosecution of that particular conviction. For framing of charge, I say that for discharge 60 days period is prescribed. Then whenever a particular offense is punishable for less than 3 years, then in that contingency, person cannot be arrested. You know the guidelines given by the Honorable Supreme Court in the Arnesh Kumar's case, that prevention of arbitrary arrest without reason or for without any just and reasonable cause. So now it is said that whenever you want to arrest any person who may be sick person, who may be infirm, or any person about the age of 60 years, and punishment is less than 3 years, so you cannot arrest him without the permission of officer below the rank of sub-divisional officer or deputy superintendent of police. That is DYSP in short. Even for arresting such person, you have to seek permission from DYSP. For investigating any crime, also permission of the DYSP is required, because certain offenses for which punishment is less than 7 years, if they needs to be investigated, if inquiry is to be made, then within 14 days, you have to make an inquiry, and then you have to ask to the superior whether you can proceed with the investigation of those offenses by ascertaining whether prima facie offense appears to have been made out. It is also in order to protect and safeguard the person should not be suffered because of scrupulous false complaints which are generally filed out of vengeance. So these are some of the important provisions that have been introduced by the new code with the object to see that trial must be conducted speedily, investigation must be completed speedily, and within a specified time period, you have to complete with the investigation. And firstly, directly registering the offense should be avoided. Instead of directly registering the offense, you have to make inquiry when punishment is less than 3 years, punishment is less than 7 years, generally against doctors or the medical representatives. False complaints are lodged, generally in matrimonial matters, under the heat of anger, under the heat of passions, out of sentiments, the reports are lodged as regards to cruelty and ill treatment. So instead of directly registering the offense and proceeding with the investigation and arresting the accused, inquiry has to be made. An object of inquiry must be to ascertain the truthfulness in the accusation. This new BNSS has done away with certain concepts which were part of the old code regarding the classification of the courts. The Court of Assistant Session Judge, which was classified under the old Code of Criminal Procedure, has been done away, and after enactment of BNSS, now we have no Court of Assistant Session Judges. Likewise, metropolitan area and metropolitan magistrate, these two terms have been done away. So metropolitan is always in respect of the population, and considering the population during the British Empire, certain areas were notified as metropolitan areas, the provincial areas, and princely states, and all these things you know well. So now the term metropolitan area has been done away, and that's why the term metropolitan magistrate has also been done away. Now there are no courts of metropolitan magistrates in Mumbai, Calcutta, Madras, or Delhi. Now we have judicial magistrates even in the so-called metropolitan areas. In Mumbai, now there will be no courts of metropolitan magistrate, but there are the courts of judicial magistrates, and they are dealing with it. Though of course not of the first class, because a metropolitan magistrate in Mumbai is equivalent to our chief judicial magistrate or additional chief judicial magistrate, and they are not at par with the judicial magistrate of the first class as we do have in district courts. So that concept of assistant section judge, metropolitan judges has also been done away. So with all the criticism, anyhow, these new laws, new criminal laws rather, have been implemented. And one of the criticism is that nothing new has been brought, and it is the old laws, the old existing sections, which are reproduced in the redrafted form or rearranged form, and by verbatim taking into the definitions as it is, and the procedural as it is, the procedure prescribed for the trial of warrant cases, trial of sessions cases, trial of summary cases, as was under the old code, has been retained. Now the term pleader has been done away and it is substituted by advocate. Pleader term was used in the British India. Now there will be no pleader, but there will be advocates in place of pleaders under the new benefit. So the procedure prescribed the different stages, right from taking of the cognizance. Cognizance means taking judicial note to the accusations. Cognizance of an offense means applying mind to the accusations, the set of accusations, and then proceeding with the trial. Because whatever charge sheet is sent, that is not desirable, that as it is, the court shall proceed with the framing of charge under all the penal sections under which charge sheet has been filed. That was the part of investigation. And framing of charge is a stage which separates the stage of inquiry from the stage of trial. Now you have to proceed with the trial, and trial must be fair. A fair trial is a trial which is fair to the accused as well as to the victim. Then it can be considered to be a fair trial. It must be fair to both the parties, victims of the crime as well as to the accused. And then you have to proceed with the framing of the charge. The object of framing of charge, at the cost of repetition, I am saying that it is the accused must know what are the accusations against me and of which I have to answer. And then comes proceeding with the evidence. The prosecution begins with the evidence in the criminal case. Then it is cross-examined by the defense witnesses. The defense of the accused can be gathered from the tenor of the cross-examination of the prosecution witnesses and as well as from the statement of the accused, which is recorded under section 313 of the CRPC under the old code. And then thereafter the arguments advanced by both the parties, and then the court proceeds with the judgment, and it has to be pronounced within 15 days after conclusion of arguments by both the parties. So this procedure, which was part of the old code, has been retained under the new code of criminal procedure, and most of the provisions, to be very honest, are retained as it is, but certain new niceties have been introduced, and with keeping in mind the very object of speedy trial and making the use of forensic sciences as well as electronic and video, audio evidence compulsory, mandatory in inquiry, investigation, as well as in the trial. So I think how far I have been able to give justice to the code and BNSS, it is for the learned participants to decide. I am thankful to Dr. Ajay Mehkarkar sir for giving me this opportunity to unfold the niceties of this old code of criminal procedure as well as this Bharatiya Nagrik Suraksha Sanhita. Thank you very much for all.
Thank you very much, sir. Before going to end this meeting, I want to contain two things, and then with your prior permission, we will end the meeting. I am very much thankful, sir, because if we observe last 1 hour, you have covered from the enactment of procedural and substantive law, how it enacted, what are the purposes of the procedural and substantive law, what are the qualities of previous criminal law, and what new things has been added in the BNSS. Means I really impressed by the views which you have put while dealing with the constitutional perspective as well as the penal law perspective. There are a number of participants who are asking something in Marathi also in my personal law. सरांनी मागच्या 1 तासामध्ये कायदा बनवण्यापासूनच्या प्रोसेस पासून भारतीय राज्यघटनेचा रेफरन्स घेतला, तिथून क्रिमिनल लॉची इनॅक्टमेंट कशी झाली, प्रोसिजरल लॉ काय, सबस्टेंटिव्ह लॉ काय, मग नवीन BNSS जो तयार झाला त्याचा उद्देश काय, तो कसा पूर्ण करण्याचा प्रयत्न झालाय, याचे नवीन ऑब्जेक्ट काय, म्हणजे एका तासात एवढं आम्ही प्राध्यापक असून सुद्धा कव्हर करू शकणार नाहीत. एवढा मोठा पोर्शन जर आपण कव्हर केला तर मी असं म्हणेल, सॉरी टू से सर, जजेस लोकांना ऐकायची सवय असते, पण तुम्ही असे जज आहात जे ऐकता सुद्धा आणि खूप चांगल्या पद्धतीनं नवीन लॉ खूप सुंदर पद्धतीने आम्हाला एक्सप्लेन करून सांगितला. म्हणून मला असं वाटतं की पार्टिसिपंट्स, वेन यू स्टार्ट युअर प्रिपरेशन ऑफ BNS, if you listen this again and again, you can easily understand entire process of trial. Means honorable sir has started from investigation and comes to the conclusion up to the trial. Investigation, inquiry, trial, along with that बेल प्रोव्हिजन काय, रिमांडची प्रोव्हिजन काय, हे सगळं कव्हर करत असताना परत एक टिपिकल प्रश्न नेहमी जे लॉचे विद्यार्थी विचारतात किंवा तो असतो की सर याला कोड का म्हणतात, याने ऍक्ट का म्हणतात, हा खूप महत्वाचा पार्ट सरांनी बोलत बोलत सहज कव्हर केला की ऍक्ट कशाला म्हणतात आणि कोड कशाला म्हणतात. सो आय हॅव लिसन लॉट ऑफ लेक्चर्स ऑफ व्हेरियस जजेस, बट रिअली want to tell you sir, this is too much intellectual and you have covered every part of minute things that is too much sufficient to understand substantive and the procedural law. So on behalf of our group, we are very much thankful sir. म्हणजे मी आता सांगायला हेतुपुरस्सर काही गोष्टी मी आधी सांगितल्या नाही. सरांनी धुळ्यात असताना दोन खूप लँडमार्क म्हणू त्याला, डिस्ट्रिक्ट कोर्टाचे असले तरी खूप लँडमार्क आणि बर्निंग जजमेंट दिलेले आहेत. आणि याचं कारणच कदाचित सरांकडे ते जजमेंट येण्याचं असावं की भास्कर वाघ प्रकरण आणि एक मॉब लिंचिंगचं जे मोठं प्रकरण पूर्ण महाराष्ट्रात गाजलं होतं, त्याचं लँडमार्क जजमेंट मी डिस्ट्रिक्ट कोर्टाचंही जजमेंट लँडमार्क म्हणेल, कारण त्याच्यावर बऱ्यापैकी इव्हन संसदेत सुद्धा चर्चा झाली होती. अशा दोन प्रकरणात सरांनी खूप सुंदर जजमेंट दिलेले आहेत, ज्याने कायद्याचं एक्झिक्युशन कसं झालं आणि त्याची रियालिटी काय, ह्या दोन्हीची सांगड लावून जे काही जजमेंट दिले त्याच्यातनं एक आदर्श ज्युडिशियरीचा मान आपण कॉन्स्टिट्यूशनचा बेस ठेवून ठेवतो असं म्हणायला हरकत नाही. म्हणून परत एकदा मी सर्व ग्रुपच्या वतीने आपले खूप खूप आभार मानतो सर. आणि आभार यासाठी मानतो की ही फॉर्मॅलिटी आहे, पण आम्ही आपल्या ऋणातच राहू इच्छितो. आपण जेव्हा शक्य होईल त्यावेळेस आपण परत यावं असं आग्रहाचं निमंत्रण देऊन आपल्या परवानगीने आजचं सेशन आपण संपवू. थँक्यू व्हेरी मच सर. एनी पार्टिसिपंट हु वॉन्ट टू से समथिंग? सर तुमच्या परवानगीने पार्टिसिपंटला काही बोलायचं तर बोलू देऊत आपण.
बिलकुल बिलकुल, मोस्ट वेलकम.
येस येस, एनीवन वॉन्ट टू
Sir.
से समथिंग? येस.
Sir, I'm Advocate Kothari.
तुमचं नाव सांगा, तुमचं नाव सांगा आणि मग विचारा. यू प्लीज कंटेन युअर नेम अँड आस्क व्हॉट यू वॉन्ट टू आस्क.
Sir, myself is Advocate Renu Kothari from Ahmednagar.
येस मॅम, येस. रेणू कोठारी.
Sir,
Yes,
सर मला एक डाऊट असा होता की 227 मध्ये ज्यावेळेस डिस्चार्ज ऍप्लिकेशन आपण फाईल करतो त्यावेळेस अॅक्युजचं जे काही थेरी असेल ती विचारात घेतली जात नाही, फक्त आपण प्रॉसिक्युशनच्या केसवर आपण ते रिलाय करतो. पण 294चा एक सेक्शन आहे, त्याच्यात दिलेलं आहे की अॅक्युजचे जे काही डॉक्युमेंट्स असतील ते पण रिलाय केले जातील. मग ते केव्हा सर? आणि म्हणजे 313च्या वेळेस का मीनवाईल कधी पण?
See, 294 was the provision contained in the old Code of Criminal Procedure that is calling upon the accused to admit ordinary document on which prosecution was relying. Under the old code, that was the practice. So far as discharge is concerned, discharge आपण केव्हा करतो की जेव्हा जे काही मटेरियल आहे, if it is gone unrebuted would warrant into conviction of the accused, तेव्हा आपण चार्ज फ्रेम करतो. तशी परिस्थिती नाही की आहे जेवढा पुरावा आहे त्याचा प्रायमा फेसी सगळं दर्शनी देखील आपण अवलोकन केला तर ते पुरावा असा म्हणता येणार नाही की त्याच्यावरून आपण खटला चालवायला पाहिजे. त्या क्षणी मग दोष आरोप सिद्ध करणं किंवा चार्ज फ्रेम करणं अँड टू प्रोसीड अगेन्स्ट द अक्यूज शक्य होत नाही, काय आवश्यक नाही. तेव्हा वी यूज टू डिस्चार्ज द अक्यूज. आता टू कन्सिडर द डिफेन्स आहे, जोपर्यंत ट्रायल होणार नाही तोपर्यंत काय म्हणजे आरोपीचा जे डिफेन्स आहे ते आपल्याला समजणार नाही. बट प्रायमा फेसी नेचरचं जे काही मटेरियल आहे विच प्रायमा फेसी शोज दॅट ही कॅन नॉट बी प्रोसिडेड विथ द ट्रायल, त्याच्यावर ट्रायल चालू शकत नाही.
सर पण
वी कॅन डिस्चार्ज हिम. आता राहिला इस्टेटचा की आरोपीचा जे काही डिफेन्स आहे किंवा आरोपीचे जे काही डॉक्युमेंट आहे ते पाहण्याची स्टेज ओनली 313 याच्यासाठी आहे there is no other stage provided for defense of the accused. म्हणजे प्रॉसिक्युशनचे जे एव्हिडन्स आहे त्याला क्रॉस डिफेन्स करू शकतो आणि त्याचा डिफेन्स जे आहे we can gather from the cross examination of prosecution witnesses as well as from the statement of the accused under section 313 of CRPC.
तर ऍक्च्युली सर 294 ची हेडलाईन अशी आहे की वेअर एनी डॉक्युमेंट इज फाइल्ड बिफोर एनी कोर्ट बाय द प्रॉसिक्युशन और द अक्यूज द पर्टिक्युलर ऑफ एव्हरी सच डॉक्युमेंट शॅल बी इन्क्लुडेड इन अ लिस्ट अँड प्रॉसिक्युशन और द अक्यूज ॲज द केस मे बी ते
Yes.
करू शकतो म्हणजे अक्यूज पण त्याचे फाईल करू शकतो ना डॉक्युमेंट मग
Accused
त्याचं
पण ते कसं आहे की 313 cannot be the part of the defense. It is neither a statement on oath, तो डिफेन्सचा पार्ट होऊ शकत नाही. But you can confront with the documents to the witnesses. 284 स्टेज कशी केव्हा आहे बिफोर प्रोसिडिंग विथ द ट्रायल.
येस
फॉर प्रोसिडिंग विथ द ट्रायल आहे. आपण ट्रायल सुरू झालेलं नाही तेव्हा डॉक्युमेंट जे दाखल करतात आपण वी कॅन रिफर दोज डॉक्युमेंट्स टू द प्रॉसिक्युशन विटनेसेस.
विटनेस
परंतु प्रॉसिक्युशनचे डॉक्युमेंट 214 मध्ये दाखल करतात दो लिबर्टी इज गिवन टू द प्रॉसिक्युशन ॲज वेल एज टू द अक्यूज. पण प्रॉसिक्युशनचं कसं आहे जर तुम्ही त्यांचे डॉक्युमेंट ऍडमिट केले तर त्यांना पुरावा द्यायची गरज नाही. तसंच तुमचे डॉक्युमेंट प्रॉसिक्युशनला तुम्ही रेफर केले आणि ते त्यांनी मान्य केले त्यांचे विटनेसेसने तर तुम्हाला पुरावा द्यायची गरज नाही. तो डॉक्युमेंट सिद्ध होतो. पण फॉर्मल प्रूफ ऑफ अ डॉक्युमेंट जे आहे 294 मध्ये प्रॉसिक्युशन दाखल केला तर त्यांचं बर्डन शिफ्ट होऊन जातो. त्यांचं बर्डन त्यांच्यावर राहत नाही जे काही इनिशियल बर्डन आहे. पण प्रॉपर स्टेज कसं आहे की डिफेन्स ऑफ द अक्यूज नीड नॉट बी प्रूव्ड बियॉन्ड ऑल रिझनेबल डाऊट अनलेस यू टेक सम स्पेसिफिक प्ली. जेव्हा तुम्ही स्पेसिफिक प्ली घेतली तेव्हा तुम्हाला बियॉन्ड रिझनेबल डाऊट ते सिद्ध करायला पाहिजे. तुम्हाला डिफेन्स कसा करायला पाहिजे ओनली प्रोबेबल.
प्रोबेबल. येस सर.
It not be proved beyond all reasonable doubt. It must only be appears to be probable. Probable. आता 498 ची केस घ्या. पहिली पत्नी असताना the presence of second wife is also cruelty. Though
Yes, sir.
if it is
Hope that
both,
you have satisfied the.
it is given to both to file the documents, but defense need not be proved beyond all reasonable doubt, like prosecution can. If you deny any document of the prosecution is bound to prove that document. But तुमचा एखादा document आहे ते prove झाला and if it is made probable also, that will suffice the purpose. Unless you have to prove certain defense specifically, like alibi आहे. 294 मध्ये दो liberty is given to both, but defense need not be proved beyond all reasonable doubt. आणि dischargeच्या वेळी जे आपण बघायला पाहिजे only prima facie, no roving inquiry shall be made in the accusations as well as in the defense. आणि डिफेन्स तुम्ही डिस्चार्जच्या वेळी ओपन करू शकत नाही कारण तुम्हाला जे काही स्पेसिफिक डिफेन्स तुम्ही घेतला ते तुम्हाला सिद्ध करावं लागेल. जर समजा तुम्ही एलिबीचा डिफेन्स घेतला दॅट मस्ट बी प्रूव्ड. एलिबी मस्ट बी प्रूव्ड की त्यावेळी जेव्हा घटना घडली तुम्ही तिथं नव्हते. नुसता डॉक्युमेंट दाखवून चालणार नाही. यू हॅव टू प्रूव्ह एलिबी. Defense has to prove alibi. So roving inquiry into the accusation shall not be made. Only prima facie बघायला पाहिजे की ट्रायल खटला चालवणे इतपत पुरावा आहे किंवा नाही तर ही सगळं दर्शनी. I think I have answered the query.
Yes, sir.
Any more
That,
questions?
yes, can we get satisfactory answer?
येस थँक्यू. थँक्स अ लॉट सर.
Okay, sir.
Sir,
Once again, very much thankful, sir, because I know that sir has come in court in early morning and yet he is for us only sitting in the court. साहेब सकाळी 10 वाजता कोर्टात गेलेले आहेत अजूनही ते कोर्टातच आहेत. हा सगळा वेळ जो आहे 5 वाजताच्या नंतरचा हा फक्त पार्टिसिपंटसाठी त्यांनी काढला. त्याबद्दल परत पार्टिसिपंटच्या मार्फत आणि माझ्या मार्फत सरांचे खूप आभार मानतो आणि सरांच्या पूर्व परवानगीने आजचं सेशन संपलं असं जाहीर करतो.
सर ऍडव्होकेट कुचेकर बारामतीहून मला ह्याच आता 227च्याच रिलेटेड एक प्रश्न होता की तू विचारू सर.
विचार.
This is the last question.
जे
Yes.
डिस्चार्ज अप्लिकेशन आता आपण म्हटलो मग ते आरोपीने ते पिटिशन देणं आवश्यकच आहे का का प्रायमा फेसी कन्सिडर करून डिस्चार्ज अप्लिकेशन नसेल तरी करता येईल.
चार्जच्या वेळी कसं आहे बघा जुन्या कोडमध्ये अशी प्रक्रिया होती प्रोव्हिजन होती की चार्ज फ्रेम करत असताना म्हणजे वॉरंट ट्रायल केसमध्ये आरोपीचं ऐकून घेणं गरजेचं आहे, तसंच प्रॉसिक्युशनचं ऐकून घेणं गरजेचं आहे, तेव्हाच कोर्टाने चार्ज फ्रेम करायला पाहिजे. पण कुणीच आर्ग्युमेंट करत नव्हता म्हणून कोर्ट डायरेक्टली चार्ज फ्रेम करत होते. आता कसं झालं, नवीन BNSS प्रमाणे 60 दिवसाची अवधी दिलेली आहे. कोर्टाने 60 दिवसात चार्ज फ्रेम करण्याची घाई करू नये किंवा अबंडंट प्रिकॉशन म्हणून असं विचारायला पाहिजे की तुम्हाला डिस्चार्ज ऍप्लिकेशन द्यायचं आहे का, की मी चार्ज फ्रेम करू, की चार्जवर तुमचं काही म्हणणं आहे का. कधी कधी प्रॉसिक्युशन सुद्धा अर्ज देऊ शकतो की याच्यामध्ये काही कलम वाढवा. तसंच डिफेन्स सुद्धा अर्ज देऊ शकतो की बाबा हे कलम लागत नाही, हे कलम कमी करा आणि दुसऱ्या कलमाखाली फक्त चार्ज व्हायला पाहिजे. तर खरोखर म्हणजे चार्ज स्टेजला दोन्ही पक्षांना ऐकून घेणं बंधनकारक आहे, पण वॉरंट ट्रायल केसमध्ये कुणी करत नाही. आता 302चा खटला आहे, 302 लागतच नाही, 326 लागतं. तर म्हणजे 326 इज ट्रायबल बाय मॅजिस्ट्रेट, 302 वॉज ट्रायबल बाय सेशन्स कोर्ट. तर हे जे आहे तर तेव्हा विचारणं गरजेचं आहे. नाही तर काय होतं, 1 वर्षानंतर 2 वर्षानंतर तो मोठं कोर्ट चार्ज करून टाकतो. तेव्हा डिफेन्स लॉयरची ही जबाबदारी आहे की तुम्हाला डिस्चार्ज पाहिजे असेल तर जेव्हा चार्जशीट दाखल झाला तेव्हा तुम्ही असं म्हटलं पाहिजे की डोंट फ्रेम द चार्ज, आय हॅव टू मूव्ह फॉर डिस्चार्ज. नाहीतरी कोर्टाने विचारला पाहिजे, पण कोर्टाने नाही विचारला. सो अक्यूज मस्ट बी कॉशियस अबाउट हिज राईट अँड ही मस्ट से दॅट आय वॉन्ट टू मूव्ह फॉर डिस्चार्ज. किंवा जर तुम्हाला लेखी अर्ज द्यायचा नाही तर त्याने असं म्हटलं पाहिजे की चार्ज फ्रेम करण्यापूर्वी माझं म्हणणं ऐकून घ्यावा. कोणी सुद्धा म्हणू शकतो की माझं म्हणणं ऐकून घ्यावा आणि चार्ज किंवा दोषारोप ठरवण्या इतपत पुरावा नाही म्हणून चार्ज करू नये आणि मला डिस्चार्ज करावा. इवन हिज ओरल प्रेयर कॅन बी टेकन इन टू कन्सिडरेशन.
थँक्यू सर.
मोस्ट वेलकम.
Yes, sir. Thank you very much, sir. Okay, with your prior permission, we will end the meeting, sir.
Thank you. Very kind
Yes, sir. Thank you for giving a lot of time.